The Lord Back tempts me. I'm thinking of T.S. Eliot in the Murder in the Cathedral. The fourth temptation is the greatest treason, to do the right thing for the wrong reason. Of course, my objectives in politics, like most people in this House, are of a moral kind. I didn't come into politics to hurt the poor. But there is a fact that, and I'm not in this making the usual party political game, but the fact is that when we came into government, we also came into the biggest financial crisis that this country had faced in 80 years. And Lord Back knows full well, because his own government were planning cuts, that whoever was going to be ministers were going to be faced with tough decisions, hard decisions. To govern is to choose. And every department has had to make tough decisions. And I don't resile from these. And if you are a department which only has 3 big ticket items, prisons, probation and legal aid, and you're asked as part of the contribution to economic recovery to find 2 billion in savings, then you're going to have to look at those 3 big ticket items. In looking at legal aid, we have been tried to look at the scope of the areas that we cover in the most compassionate way. I don't, and I've answered questions before on this, if you have a part of your government system that is targeted on the poorest sections of your community, and you cut that budget, then you are going to hurt those sections of the community. And that's the same thing as is happening with local authorities around the country in looking at their various budgets and other departments. It is too easy, and I've got to say, even with Lord Back at the end, not one of the contributions that were made actually put forward a hard choice, as if they were on this side of the dispatch box. It's all right to say that we had plans to raid criminal legal aid, or the Law Society are going to shift it on to the drinks industry, or Lord Haskell is going, I think the jargon is the polluter pays, spread it around Whitehall. But even spreading it around Whitehall leaves the Exchequer with the need to save the money. So, you know, I do understand, and I do not doubt the passion that has been expressed today, and some of the very valid points, and I'll try and deal with specifics as I go through. I understand it. We are still in consultation. I can't say that the consultation is going to produce some poor line conversion at the last moment, because, as I say, we have made a commitment to savings, and we intend to deliver them. What we have tried to do, as I say, is look at the whole philosophy of the system of legal aid, which a number of speakers acknowledged had grown and expanded since its introduction in 1949. I actually went to see Lord Hutchinson, Jeremy Hutchinson from the Liberal benches, who's I think now 96, and in splendid form, although he no longer attends. But he was part of that generation that formed the original Hay. And he said to me, our hope then was to create the parallel legal system to the National Health Service. I don't doubt what was behind and is behind the legal aid system. We share that. The consultation that we put out has produced nearly 4,800 responses in total. I can't give the detailed government response today. We will be announcing that in the next few weeks. And I can assure you that what has been said and the various points made will be fed back into that consultation. Before addressing the particular points made in the debate, I wish to reiterate briefly some of the considerations the government bore in mind in making these proposals. The context of the government's overall reform is, as I've said, to tackle the deficit we inherited on entering office. Last October, the spending review set out the scale of the challenge facing the Ministry of Justice. However, as the government has stressed, we know that our policy cannot simply be determined by dealing with the deficit, and neither are we doing so. There is considerable potential for reform within the justice system. Our legal structures and our legal aid system are capable of reform. So financial considerations and the need for reform come together. There are many reasons why we believe it necessary to reform legal aid, many of which have been acknowledged today. Since the modern legal aid system was established, its scope has been widened far beyond what was originally intended. By 1999, legal aid funding was available for virtually every type of potential issue, including some which should not require any legal expertise to resolve. The scheme now costs over $2 billion a year, making it one of the most comprehensive schemes in the world, even taking jurisdictional differences into account. And we need to understand that even after reform, we will still have one of the most expensive schemes in the world. In developing our legal aid reform proposals, we went back to basic principles to make choices about which issues are of sufficient priority to justify the use of public funds, subject to public means and the merit test. The proposals in the consultation paper aim to take into account the importance of the issues at stake, the litigants' ability to present their own case, the availability of alternative sources of funding, and on alternative routes to resolving disputes, as well as our domestic and legal obligations. To focus financial support on the areas where it is most appropriate and most necessary, the proposed reforms involve significant change to the scope of legal aid funding. We did not propose any change to the scope of criminal legal aid, and it was also proposed that legal aid will still be routinely available, as a number of colleagues have said, in civil and family cases where people's liberty is at stake or where they are at risk of serious physical harm or immediate loss of their home. For example, we propose to retain legal aid for asylum cases, for debt and housing matters where someone's home is at immediate risk, and for mental health cases. Legal aid will still be provided where people face intervention from the state in their family affairs that may result in their children being taken into care. For cases involving domestic violence, and I note the comments that have been made on that, or forced marriages, and I'll deal with that later, and for immigration cases, where the appellant's liberty is at stake. We also propose that legal aid should be available for cases where people seek to hold the state to account by judicial review, and for the cases involving discrimination that are currently in scope. Legal help to bereaved families and inquests would also remain in scope. However, prioritising those areas requires that we make clear choices about the availability of legal aid in other areas. We therefore propose to remove from scope of the scheme issues that are not, relatively speaking, of sufficient priority to justify funding at the taxpayer's expense. We propose to cease providing legal aid support for private family law cases unless domestic violence, forced marriage or child abduction is involved. Too often the long drawn-out, acrimonious nature of court proceedings exacerbates disputes between couples rather than solving them. Under our proposals, we would continue to provide funding for mediation, to encourage couples to use more effectively methods to resolve issues between themselves rather than using the court. We are not proposing mediation as a cure-all in place of litigation, and I will say more of that shortly. The Government further proposes to remove from scope of civil legal aid schemes claims of clinical negligence, where in many cases alternative sources of funding are available, such as no-win, no-fee arrangements. Again, I note the points that were made on that. We also propose to remove from scope the categories of employment, education, immigration, some debt and housing issues, and welfare benefits. Exceptions will be made for some of these cases where there is a risk of anyone's safety or liberty, a risk of homelessness or discrimination. In many of these cases, the issues are not necessarily of legal nature, but require information, practical advice, or other forms of expertise to resolve. We recognise that there would be some cases within the areas of law we propose to remove from scope, which international or domestic law would require to be funded by the taxpayer. We therefore propose a new exceptional funding scheme for excluded cases. But can I say to my noble friend and old folk, we will take a very hard look at issues on the international side of things. It won't be an open checkbook on that. The impact of the reforms on existing claimants and various groups who would no longer have access to legal aid is something that we are looking at. We recognise that there would be some impact of the proposals on existing claimants or various groups if issues were no longer to fall within the scope of legal aid. However, this does not mean people would be unable to resolve their issues. Straightforward mechanisms are often available to assist. For example, in many tribunals, such as employment, legal representation is not currently available because they are designed to be used without legal aid. We published an initial impact assessment and an equality assessment alongside our consultation, and when we publish the final response, we will also push, partly in answer to Lord Tui's point, we will update the impact assessments. There is limited evidence about the impact of proposals on the case length of litigants in person, and the findings are mixed. We do seek to simplify procedures. The forms and guidance available to those using the court in person. We do recognise that mediation may not be appropriate for all individuals, but it is important for them to consider it as an option, and we are currently making it easier for individuals to do so. When successful, mediation may hold considerable advantages, as it can be cheaper, quicker and less acrimonious process than those contested court proceedings. Public funding for family mediation has been made available for more than a decade. This has proven to be a successful policy. With effect from 6th of April, we introduced a pre-application protocol for family mediation information assessment meetings. Any individual, self-funded or public-funded, will be expected to consider mediation before beginning proceedings. However, family proceedings in relation to domestic violence or emergency proceedings are expressly outside the scope of this requirement. This is a big step forward to improving awareness and encouraging take-up of family mediation. On civil mediation, the Government is currently consulting on the paper Solving Disputes in the County Courts, Creating a Simpler, Quicker and More Proportionate System. The proposals are to require all cases below the small claims limit to attempt settlement by mediation before being considered for hearing, and the introduction of mediation information and assessment sessions for claims above the small claims limit. We recognise that we cannot, of course, compel parties to settle, but we can create a better environment within which settlement can be explored. This consultation closes on the 30th of June. My Lords, if I could look at some of the specific issues that I haven't covered in that. Some of the points made, for example, by Baroness Sherlock on asking for a time lag, I'm not sure that is something that can be done, but I will feed that back to colleagues. The question of clinical negligence, and that point was raised by Lord Folkes and a number of other colleagues around the House, including my colleague Lord Thomas of Gresford. This will undoubtedly be a matter of some debate when legislation reaches both the other place and here. The confidence that the CFAs will cover that area is something that is going to be, I'm sure, very hotly debated, and we can certainly reconsult Lord Justice Jackson on that. The Lord Dubs was concerned about forced marriages. I think that I better just double check before I sell the pass on this, but I think that the forced marriages will remain within scope. We propose to keep legal aid for these cases, including the power to waive the upper financial eligibility in these cases. So I hope that helps. I fully acknowledge the point that Lord Hart made about the pro bono help from the legal profession. But it's, and we will look at the question of advice deserts. I mean, that is something that has been raised, and we will look at that as a matter of concern. Lord Haskell, as I say, it's a neat option to the polluter pays, but in the end, the Treasury wants its money. But we are looking at the evidence given by the Law Society, the point that Lord Beecham mentioned, and we will give consideration and publish our responses in due course. I take the point that my noble friend Lord Thomas made about people inserting domestic violence to get themselves in scope, and that would have to be advised. Baroness Sherlock emphasised the need for advice. I suppose where we differ is whether what the advice is always needed is legal advice, and whether we in fact force people into legal advice. Going back to Lord Folkes, I mentioned that we will look very hard at requests under the human rights issues, and the government wants funding on only serious and significant cases. I will also feed back his concerns, as expressed by others, about clinical medical negligence. With Baroness King, the consultation paper was clear, and I was passed it up, it's around here somewhere, and it does clearly say that we were going to take clinical negligence out of scope, and that says it very clearly in the document. If she sees a contradiction, I'll be happy to talk to her about it, and quite clearly, because I too received her letter, there is going to be a campaign on that. Lord Listowel asked for assurance about children who need separate representation in family cases. Yes, we propose to keep legal aid for children where they have been made a party for the case in family proceedings. Baroness Kennedy took some cheap shots at my friend Jonathan Janogley, who is a very, very good solicitor. He's a very good solicitor. And Lord Crisp, as a former permanent Under-Secretary, I give full deference to his advice, but I'm sure in a long and distinguished career he must too have sat there with a Treasury demand notice and a programme of cuts to be pushed through. On special educational needs, Lord Toohey's point, special educational need tribunals have been designed to be easy and accessible, and we're considering the points he made during consultation. I'm now being tugged at that my time is up, because if there are points that have been made that I've not yet had a chance to raise, I will write to colleagues. Like Lord Bark, I agree this has been an extremely timely debate because we are still in consultation, and it has been an extremely useful one because those who have contributed from real expertise and real commitment. We are listening. We have some tough decisions to take. We will not flinch from those tough decisions, but neither will we ignore common sense when it's offered to us.